At the outset, I would want to establish that arbitrary withholding of consent to relief operations is a violation of international humanitarian and human rights law, giving rise to state responsibility for wrongful conduct. The wrongfulness authored by Israel would then evoke its responsibility under the law of state responsibility as outlined by my colleague, Dr. Azarova. This is an instance in which steps have been taken by third states to invoke the responsibility of Israel, the occupying power, and the pursuit of additional measures to ensure respect for the law and safeguard the provision of relief continues. It is triggered by the fact that Israel, in various ways, impedes humanitarian relief to the Palestinian population in the West Bank, including East Jerusalem and the Gaza Strip. We assess the legality of these measures in light of the general law governing belligerent occupation and the rules concerning relief operations contained in the Hague Regulations of 1907, the Fourth Geneva Convention, Additional Protocol 1, and customary international humanitarian law. At the core of the legal issues addressed is the obligation of an occupying power to provide for the well-being of the population of the occupied territory, short of bringing the occupation to an end. Destruction and seizure of Palestinian property and remedial humanitarian aid surged in 2020, with a higher monthly number of demolition incidents than 2016, which previously represented a high watermark. Israel continues to destroy Palestinian property despite the COVID-19 outbreak in the West Bank and despite pleas by the international community to cease destruction. From January 1st to October 2020, 575 Palestinian properties in the West Bank, including East Jerusalem, have been destroyed or seized, adversely affecting 3,500 persons, as recorded by UN OCHA. 38% of the structures demolished were residential, followed by agricultural assets, livelihood-related structures, and water and sanitation facilities. There have been over 100 donor-funded structures destroyed so far this year, 50% of which were provided as humanitarian relief to Bedouin and herding communities at heightened risk of forcible transfer. The European Union's 6-month report on demolitions and seizures in the West Bank of May this year provides a financial estimate of damages incurred by European donors. For reference, from 2014 until the end of 2019, approximately 536 structures funded by the EU and EU member states were destroyed or seized by Israeli authorities, representing an accumulated value of 1.8 million euro. Approximately 1,000 structures funded by the EU and the EU member states with a value of around 5 million euro were at risk of demolitions at the end of 2019. So based on this, the estimated damage to EU-funded relief, the bulk of aid provided to Palestinians residing in areas C of the West Bank since the beginning of 2020 stands at over 600,000 euro, in prejudice of the intended beneficiaries, the contributing state, and the norms governing relief action in occupied territory. There is a perpetual risk to personal property and community assets. That threat to private property and community assets is constant. One such example is the planned demolition of a European funded Palestinian primary school in Ras Atin, a herding community in the central West Bank. The school serves 50 students from 1st to 6th grade who otherwise would have to walk around 5 kilometers to access the school in the nearby El Muhair village. The European Union, several of its member states, and the United Kingdom provided humanitarian funding for the construction of the school. The Israeli military confiscated construction materials and tools on 4 occasions between August 31st and September 10th, just before the school year commenced, including the school's roof, desks, and chairs, under the pretext that the school lacked an Israeli-issued building permit. Note that the Israeli authorities deny as much as 98% of Palestinian requests for building permits in Area C. It's virtually impossible to acquire such a permit. According to the education cluster, Israel has partially or fully demolished 3 schools in the West Bank so far this year, and 52 other schools are under threat of demolition. NRC Secretary General Jan Egeland recently urged Israeli authorities to immediately seize the unlawful destruction and seizure of property in the West Bank, including humanitarian relief items. He called on the international community to ensure Israel abides by international law and joins the global call to end political conflicts, to fight the COVID-19 pandemic rather than escalate the vulnerability of Palestinians under occupation. Turning quickly to Gaza, and as I will shortly demonstrate, the occupying power must allow the movement of goods in relation to relief consignment, embodies 2 separate obligations pertaining to consent to relief operations and facilitation of the relief operation. In light of the humanitarian crisis in the Gaza Strip, Israel must allow the consignment of foodstuffs, medical supplies, means of shelter, and other essential supplies into the Gaza Strip. Travel to and from Gaza is at a virtual standstill. Since March 8th, Erez crossing connecting the Strip and the West Bank has been closed, except for a small number of urgent humanitarian cases. Israel is refusing to process applications for travel other than urgent medical cases, citing the COVID-19 lockdown and problems with Palestinian Authority coordination. Transit of goods via Kerem Shalom has continued at similar levels throughout the pandemic, with the exception of recurrent punitive measures by Israel, which included the restrictions and blocks on the entrance of goods in response to the launching of projectiles towards Israel. So let me now turn quickly to the legal rules for the protection of the right to humanitarian assistance in armed conflict, including situations of belligerent occupation. Such rules regulate the conduct both of the states party to a conflict and of neutral powers offering aid to adversely affected persons. The rules governing relief are found principally in Common Article 9 of the First, Second, and Third Geneva Conventions of 1949, Articles 10, 23, and 59 of the Fourth Geneva Convention, and Articles 69 through 71 of the First Additional Protocol of 1977 AP 1. In particular, Article 59 of the Fourth Convention, referring to the situation of an occupied territory, requires the occupying power to accept relief supplies if the population is inadequately supplied. The provisions of Article 59 are compulsory. Article 69 of Additional Protocol 1 supplements the Fourth Convention, reading that in addition to the duties specified in Article 55 concerning food and medical supplies, the occupying power shall, to the fullest extent of the means available to it, and without any adverse distinction, ensure the provision of clothing, bedding, means of shelter, other supplies essential to the survival of the civilian population of the occupied territory, and object necessary for religious worship. In summary, Israel must allow the consignment of essential supplies provided by third states, international organizations, and impartial humanitarian organizations. An Israeli refusal to admit relief would therefore amount to willfully impeding essential supplies as provided for under the Fourth Geneva Convention and Additional Protocol 1. An element of complexity in these otherwise simple rules is the requirement of supposed consent, purported consent of the occupying power to admit relief to the population under its actual authority. While states, third states, and humanitarian organizations may offer their services, consent is usually required before relief operations are implemented. Notwithstanding, a party refusing consent in any situation has to do so for valid reasons, not for arbitrary or capricious ones. Flowing from that is an exception to the general rule requiring consent to relief operations applied in situations of belligerent occupation. If it is not in a position to ensure the adequate provision of supplies essential to the civilian population and the restoration and maintenance of public life, the occupying power must accept relief offers that are humanitarian and impartial in character. It should be noted that two conditions must be met before the issue of arbitrariness or otherwise of withholding of consent arises. First, relief must be necessary, and civilians, as we've suggested, must be inadequately provided with essential supplies, and the party in whose control they are unable or unwilling to provide the necessary assistance. And the actor, be it state, international organization, NGO, offering its services, offering the humanitarian relief, must provide the assistance in a principled manner. What does that mean? It must be exclusively humanitarian, impartial in character, carried out without any adverse distinction as to the area of operation, the beneficiary receiving the relief. If these conditions are not met, consent need not be given. But if they are met, consent may not be withheld. Humanitarian assistance is also often considered from a human rights angle, which requires withholding of consent not to violate particular rights, most notably the right to life, or prevent the realization of economic and social rights, such as the rights to an adequate standard of living, to food, to housing, to health. Noting that selective withholding of consent with the intent or effect of discriminating against a particular group or section of the population equally violates the state's international law obligations in the realm of human rights. As we would shortly hear from Professor Link, decisions adopted under Chapter 7 of the UN Charter are binding on all United Nations member states and override their duties under other bodies of law. If the Security Council, acting under Chapter 7, demanded that relief operations be allowed into the country, the affected state would be required to comply. And while the binding nature of decisions adopted under Chapter 7 is uncontroversial, it has been recognized that Council decisions not adopted under this chapter may also be binding within the meaning of Article 25 of the UN Charter if they employ a language of obligation. Now, let me turn to legal consequences of wrongfully withholding consent. We've established where it will be permissible or lawful to withhold consent and where it would be wrongful. But what would be the legal consequences? Since arbitrary withholding of consent to relief operations is a violation of international humanitarian law, undertaking relief operations could be construed as a measure under Common Article 1 to the Geneva Conventions, calling on all member states, on all parties to the Geneva Convention to respect and ensure respect for the conventions in all circumstances. Consequently, the unlawful denial of consent for relief offers extended to the people of occupied Palestinian territory would be in violation of IHL erga omnes obligations owed to the international community as a whole. In such circumstances, states that are not directly affected by the violation would be entitled to resort to or take countermeasures. It's likened to such instances of states taking countermeasures, lawful countermeasures, in response to other violations of erga omnes obligations, most notably the imposition of unilateral economic sanctions in response to serious violations of human rights. For states wishing to construct their relief schemes in the illicit absence of consent as lawful countermeasures, those must meet several conditions that I want to stress. First, they may be brought by state or international organizations directly affected by a violation. So for present purposes, one such international organization state whose offer of assistance was arbitrarily rejected, or possibly a state whose funded relief items were wrongfully seized or destroyed. Second, the purpose of the countermeasure must be to induce the wrongdoing state to comply with its obligations under international law and remedy the violation, with the caveat that putting humanitarian aid at the disposal of NGOs and other international organizations to be delivered clandestinely to the victims of conflicts or directly undertaking a clandestine operation cannot be considered a lawful countermeasure. I want to stress that because it does not serve the purpose of a countermeasure, that of compelling the defaulting state, the defaulting occupying power, to fulfill its obligations, to either provide to the population under its authority or admit the offers of relief schemes on behalf of that population without denying, arbitrarily, unlawfully denying consent, doing so, facilitating its delivery in a timely and impartial fashion. So with that, let me turn to a few observations in conclusion and recommendations. Israel, as the occupying power, is bound, as we have demonstrated, by an obligation to provide for the well-being of the population of the occupied Palestinian territory. This position becomes even more important in the context of a prolonged occupation in which the occupying powers duties extend beyond the immediate humanitarian needs of a population that are caused by open hostilities and extend to the maintenance of public life and good governance. Therefore, it's evident that Israel has no latitude to withhold consent to humanitarian relief operations while administering occupation, including in relation to destruction of property and the limitations on maritime blockades and closure on land imposed on the Gaza Strip. Second, attempted formal annexation or acquisition of occupied territory by Israel and the subsequent intended supplanting of international humanitarian law and the law of belligerent occupation would be in violation of peremptory norms of international law. Its responsibility for the wrongfulness could be invoked. Israel's responsibility for the wrongfulness could be invoked by, among other means, the introduction of humanitarian relief schemes as a lawful countermeasure. Third, the continued provision of relief in OPT is in itself a manifestation of the duty not to recognize as lawful a violation of peremptory norms of international law, as it upholds the distinction between sovereign territories and territories coming under belligerent occupation, to which states apply international humanitarian law, extraterritorial human rights law, and significantly the corollary rules on relief that we have discussed. And finally, should consent to the continued provision of aid be unlawfully withheld, including in the context of an attempted acquisition of territory by Israel and the supplanting of the rules governing relief, the aid operation undertaken by states and impartial humanitarian organizations could be construed as constituting a lawful countermeasure against the illegal act of withholding consent. Thank you.